Well, I find this quite remarkable because if there's one thing that is really unnecessary, it's the public termination of your representation. So let's talk a little bit about attorney withdrawals and what this actually means. So, from a practical standpoint, Elaine being withdrawn from representation really just means that her name is no longer going to be on the signature form for documents that get filed in the case. It's an interesting choice because it's not necessary. You're perfectly able to hire new lawyers and add them to your team without getting rid of your old ones. Just if there is nothing for her to do, she wouldn't presumably be billing for anything. But there's nothing inherently wrong with keeping your existing legal team. Their names continue to appear on your pleadings. So this choice to remove her is a little bit telling. I suspect there are a couple of reasons why this could be. Let's start by looking at the rule of professional responsibility that deals with attorney withdrawals. And so what we see, first off, there are mandatory withdrawal situations and there are discretionary withdrawal situations, basically meaning under these circumstances, the attorney has no choice. You've got to get out of the case. And under these other circumstances, it's up to you to decide if you really want to or not. So mandatory withdrawal situations include continued representation is going to result in a violation of the RPCs. That can be a situation where a conflict of interest is going to emerge. It could be a situation where continued representation is going to require, let's say a misrepresentation upon the court, something along those lines, that because you can't do that, your alternative is to get out of the case. Second situation, the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client. We have no reason to believe that Elaine is ill or has mental problems in any significant way. Number 3, the lawyer's discharged. Client fires you, you're out. It's done. You no longer have any say. So there are other situations, though, where you may choose to withdraw, but it isn't going to be required. And so those typically involve situations where there are personal conflicts, perhaps moral conflicts. You don't like what the client is asking you to do. The client isn't paying your bill. These are situations where it's not inherently required for you to get out, but it's understood that you might want to. And so the rules give the attorney the right to be able to withdraw under those types of circumstances. The rule also lays out what the requirements are by the withdrawing attorney in terms of this cooperation that Elaine has pledged to Amber and her new legal team. The lawyer does have an interest, an obligation to maintain the continuity of the representation, to make the transition smooth. And so they are required to do what they need to do to protect the client's interests. So, for example, if you have funds that you're holding that have not been earned yet, like a retainer type of deposit, you have to return those. You also have to assist in transferring your files and your records to the new attorney. Virginia's rule is fairly specific and thorough about what this looks like. So I would say we can assume from the statement by Elaine that she intends to fulfill these obligations to the letter. Does she intend any more than that? Well, she didn't pledge it, now did she? So the rule gives us the circumstances for when withdrawal is required and when it's mandatory. We don't know what circumstance applies to this particular situation, but we can certainly speculate. One possibility is that because we've seen this emerging insurance litigation that raises some questions about who is paying for Elaine, the representations made about who is paying Elaine, these can potentially give rise to conflict of interest types of situations. Elaine may be called upon to explain her basis for eliciting that testimony from Amber Heard that she had paid for $6 million in legal fees. As Amber Heard's attorney, that is bound by confidentiality, but to the extent it implicates her own ethical considerations, and in fact, she may be under a duty to do that as a result of a court order arising from this type of litigation. Not saying there is one, I'm just saying hypothetically that could happen. Those would create a conflict of interest situation, and so that would necessitate Elaine no longer being able to represent Amber. Certainly possible that there may be personal conflicts. We have seen Amber already fire 2 sets of attorneys when she didn't get the outcome that she was looking for. Her first representation in the case was by Eric George. He had moved to dismiss the case or have it transferred to California. That was not successful. After that effort failed, she then hired Roberta Kaplan. Roberta Kaplan sought to get the case dismissed on the grounds that essentially it didn't adequately plead defamatory statements, that the comments that Amber made in the op-ed were not actionable for a variety of reasons. And that motion was also not successful. And a short time later, Roberta Kaplan was also fired and then replaced with Elaine Bredhoft. So I suppose in that respect, maybe it's not surprising that once Elaine Bredhoft failed to convince a jury that Amber Heard was not lying about all of the abuse that she described receiving from Johnny Depp, that Amber Heard would act consistent with this pattern and be done with Elaine Bredhoft as well. Certainly possible, plausible interpretation of the events. What I do think, though, that we can infer from this very public severance of that relationship is that it is not amicable. There is no reason to need to make this announcement. If it's kind of a technical decision anyway to remove a lawyer from the team rather than simply just adding on new ones for the new task, there is even more of an implication of what is going on behind the scenes that comes to light from the need to announce it, to make it clear we're done, we no longer have this continuing relationship. So many of us predicted long ago that once Elaine's role in this case was done, it would be under the tires of the bus with her. And I think what we see from this statement is indication that that is very likely to be the case. So a question that a lot of people have had in light of that is